Hi, I'm Dan Tibbs, and this is my assignment 2 for Unit 5 of the HNC Level 4 Construction. In my screencast today, I will present you my detailed plan for the contractor to reduce the legal impacts of a large urban construction project, and in this context, we're talking about the Platon. So in the screencast, I will attempt to hit M3 and the first part of D2, as highlighted here, and then the second part of D2 along with P5, P6, P7, P8, M4 and D3 have all been addressed and achieved, I believe, in the document that I'll submit along with this screencast. So to start with, you can see here, all in red is the phase 1 demolition, in blue here is phase 2 demolition. And during the demolition, there could be many opportunities for nuisance to occur, whether that being in the form of sound, dust, or vibrations. The contractor's at risk quite a lot of the time. So when we're talking about sound, when the phase 2 demolition to the left here is taking place, these properties are going to be exposed to the most sound, which provides the most nuisance to these and gives them ground to take a tort out on the contractor. Similarly, during phase 1 demolition here, these properties over here will be most exposed to sound and will give them grounds to take out a tort of nuisance on the contractor. To reduce these implications, the contractor should look to do all the demolition during a 9 to 5 period when the occupants of these dwellings surrounding the site are most likely to be at work and not actually sited in their dwellings. Consideration must be taken for the school next door, with the entrance just being here, because obviously sound will affect them and affect their learning. So special consideration must be taken during the 9 to 5 period, or the 9 to 3 in terms of the school. During the demolition, dust can cause nuisance to the surrounding properties, but mostly to these properties here to the south of the site, or the southeast, because of the large change in ground level running down this way, with these being lower. And with these being lower, the dust is more likely to set on these sites here. So the contractor must take special consideration to possibly putting a barricade up here along this boundary to prevent dust falling onto these properties. If during the construction phase the contractor has an issue with ground conditions on the site, and piled foundations are required, then a lot of vibrations can be caused from this process, which can affect properties and cause a nuisance and gives them grounds to complain, grounds to take out a tort on the contractor once again. So I'd advise that the contractor would do this during a 9 to 5 period when it would least affect people in this area, because during that period, most of the occupants probably won't be in their properties. When regarding trespass as a legal implication, the most common Most common reason for trespass would be when a crane or scaffolding is oversailing or protruding onto someone's land. So wherever the crane may be sited on the site, if necessary, permissions would need to be in place with. So if the crane was sited here, permissions may be needed from this property here to allow the crane to oversail their property without them taking out a tort on the contractor. And scaffolding, for example, if scaffolding was in place here, along this boundary, then the scaffolding will most likely oversail onto Charterhouse's land here. So it's advised that the contractor requests permission from the properties where the trespass may occur to reduce the risk of the legal implications associated with trespass. And of course, if in a case where the landowner will not consent to a permission, the contractor can highlight this with the court, and the Access to Neighbouring Land Guernsey Law 2016, which is taken from the Access to Neighbouring Land Act 1992 from the UK, will allow the court to overrule the neighbouring landowner and put a permission in place for the work to be carried out with no trespass to be sanctioned. Trespass can also occur if a delivery coming to the site is placed on a neighbour's land, or if a vehicle itself is parked or placed on a neighbour's land, so any land in the area that isn't owned or isn't under control of the occupying contractor, can cause sanction for trespass, actionable as a tort, to the owner of the land. So if any materials or vehicles are needed to be placed on another person's land, a permission should be requested beforehand. A nuisance could be caused in the form of...
It's 22 hours.
In the form of vehicles, as Little St John Street here is one way coming towards the site, and Summerray Street here going away from the site is one way. So with this in mind, any vehicles that are placed along these roads, with them being very narrow, can cause nuisance to cars trying to pass these roads. And considering considering the school here as well, so during busy times when parents are picking up their children or dropping them off, if heavy vehicles are placed along these roads here, the contractor could even be sued for negligence for blocking a large amount of cars at once. So my suggestion to prevent that would be to ensure that all cars, all vehicles, all vehicles associated with the site are placed on the site at all times, and not blocking any roads, to allow for all vehicles and traffic to pass through smoothly and easily. When considering occupier's liability, the contractor has certain liabilities within the site to protect anyone, any visitors, any public officials, any health and safety officers, any planning and building control officers that enter the site, or anyone that is trespassing and enters the site, they have a liability to ensure a certain level of protection against any injuries. So I would suggest that the contractor provides boundary fencing, boundary security to ensure that as little people can get into the site, well, so that no one can get into the site, to prevent the legal implications of the occupier's liability if someone was to get hurt on the site. And I'd suggest that they put warning signs up along all of the barriers on the boundary, so that they have that as backup if someone did happen to get injured. They have evidence that they've correctly signposted the dangers associated with entering the site. And with the school being here, the contractor must take special consideration into the fact that there are going to be children around the site, so they must put extra protection, extra security around these sort of areas by the school, so that no children can enter the site. When it comes to avoiding the legal impacts of vicarious liability within the contractor's own employees, they can provide site inductions for all of their employees before they start working on the site. Just give them some basic health and safety ideas, advice, and keep them safe on the site. They can also do health and safety checks within the site, undertaken by the contractors. They can ensure that all employees have their passport to safety to ensure minimal injuries occur on the site. When it comes to vicarious liability and subcontractors, the contractor must ensure that any subcontractors that they employ to work on the site should be trusted and experienced in their individual roles, individual trades, possibly subcontractors that they've used before and that they know are good and reliable. They can also ask subcontractors to provide their RAMs. And for example, using the crane as an example, avoiding vicarious liability there relates to the trespass that I was on about before, and obtaining licenses or permissions where required. So I believe that's pretty much it for my strategy, and I believe that I have produced I've designed a detailed plan for the contractor, because I've stated all the possible legal impacts for the large urban construction project. I've also presented a way in reducing and nullifying, and in some cases just preventing altogether, the legal impacts that I've stated.